Hi, everyone. Thanks for joining us today for our webinar delving into the implications of the Supreme Court's recent decision about the constitutionality of the Federal Impact Assessment Act. My name is Alexis Stoimanoff, and I'm the Communications Director at West Coast. I'm very grateful to be here today on the beautiful unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations at the West Coast office in Vancouver. And it looks like we have a lot of folks joining from different places across the country. So I would invite you, if you're comfortable, to use the chat and introduce yourself and let us know where you're zooming in from as well. So today's session is the first in two webinars that we're hosting this fall to assess the impact of the Supreme Court's decision. Today, our panelists are going to be sharing their overall analysis and some of the key takeaways from the decision, as well as what comes next. And then on November 14th, we'll have a second webinar that will take a deeper look at some of the implications specifically for climate policy. So to introduce our panelists today, first we will be hearing from my colleague Anna Johnston, who is a staff lawyer and West Coast's lead on the impact assessment file. And she'll be presenting an overview of the court's opinion and her perspective on next steps. And then we'll be hearing from Stephen Hazell, who's counsel at Nature Canada, and he'll be discussing some of the constitutional, political, and legislative impacts of the decision for nature conservation, as well as where we go from here. So Anna and Stephen both have extensive knowledge and experience with federal environmental impact assessment, and they've collaborated on this issue for many years, most recently representing our two organizations to intervene in the Supreme Court's reference case, where West Coast represented Nature Canada as well. There has obviously been a lot of commentary and a lot of questions raised about this decision, so we're looking forward to getting into some of that today. We encourage you to submit your questions through the chat as well as the Q&A function at the bottom of your Zoom window, and we will be reserving the questions to discuss later during the Q&A. I should also note that this webinar is being recorded and will be circulating the webinar recording to anyone who's registered after the event. I think that's it for the housekeeping. So let's dive in and I'll pass it over to Anna. Thanks.
Great. Thanks, Alexis. Good morning, everyone, or good afternoon, depending on where you're joining us from today. I'm so glad to virtually see you. I'm zooming in from the unceded territory of the Algonquin and Anishinaabe people here in Ottawa. And today, I'm going to give an overview of the Supreme Court of Canada's opinion in the Impact Assessment Act reference case, focusing mostly on the majority of opinion. I'm going to try to do that in about 20 minutes, so it really will just be an overview. For a more detailed analysis, you can check out my blog by scanning that QR code on your screen, and I think Alexis is also going to put a link to it in the chat. I'll begin with just a reminder of what the act is that we're dealing with, and then give a really high level overview of the opinion, both the good and the bad. Then I'll talk about the constitutional division of powers, which is really at the heart of the issues in this case. And then I'll go into the main findings of the majority of the court and why it found the act to be unconstitutional in a bit more detailed. And finally, I'll follow up with my analysis of what the main implications are likely to be for federal impact assessment in the future, and then wrap it up by explaining what federal officials say are going to happen next and key amendments that could bring the act into conformity with the opinion. So the act was enacted in 2019. It replaced the Canadian Environmental Assessment Act 2012. It's our fourth federal assessment law, and this year actually marks the 50th birthday of doing federal assessment in Canada. So fundamentally, impact assessment is an information gathering and planning tool that's aimed at understanding and then avoiding or mitigating the adverse effects of projects before they occur and enhancing their benefit. The Impact Assessment Act is designed to only apply to major projects, so what have ended up being 10 to 12 projects per year that have the most potential for adverse effects in federal jurisdiction. Those projects are designated either in regulations, project list regulations according to their type and size, or by designation by the minister at the request of a member of the public or an Indigenous nation or community. And while the Act sets out a long list of factors to consider during assessments, At the end, the minister or governor in council decides whether the federal effects of the project are in the public interest in light of the assessment report and 5 enumerated factors, including things like whether the project fosters sustainability, hinders our climate action, or impacts Indigenous rights. So, the opinion. I want to reiterate that this is just an opinion. It was a reference case, meaning that the Supreme Court's findings are not binding on the federal government, but it is customary here in Canada to respect the non-binding opinions of courts, and the minister has said that Canada will respect this one. So a 5-judge majority led by Chief Justice Wagner found the act to be unconstitutional in part. So the majority divided the act into 2 schemes, what it's calling schemes, one being the provisions set out in sections 81 to 91 that require minor assessments of projects that occur on federal lands that are federally funded or projects outside Canada. And the other scheme that it identified is what it's calling the designated project scheme. So the one I mentioned earlier that applies to major projects that occur on provincial crown lands. The majority took no issue with the first scheme. It's the designated project scheme that it identified some problems with that ultimately rendered it unconstitutional. And I should note that there is actually a 3rd scheme in the Act governing regional and strategic assessments. The majority didn't mention that scheme, and so presumably it stands as constitutional. A 2-judge minority found the entire Act to be constitutional. And before I get into the main findings, I just want to say at the outset that my main takeaway from reading this opinion is that it doesn't actually change much. So the issues the majority found with the Act are mostly concerns about how authorities may have exercised their discretion in unconstitutional ways. The agency and the minister have long said that they intended to exercise their discretion constitutionally in a way that aligns with the majority opinion findings. And so ultimately, I keep saying that despite the headlines, this was not the win that Alberta was hoping for. And in fact, we got some important affirmations about federal authority over environmental impact assessment, which I'll come back to at the end of my presentation. But most importantly, the majority rejected the main thrust of Alberta's arguments that the federal government has no business assessing projects or saying no to adverse federal effects. It confirmed that Parliament does have jurisdiction to enact impact assessment laws. It just needs to fix a few things in this particular law that are at play. So it upheld the project list approach as constitutional and found that only a low jurisdictional threshold is enough to trigger an assessment. So you only need potential for federal effects, not proof of federal effects, in order to designate a project. It upheld the list of factors set out, finding that in assessments, there's no constitutional limit on what authorities can consider. And it confirmed that Parliament can regulate the federal aspects of projects, including by saying no to adverse effects on areas of federal jurisdiction. So these are important findings. Some of them are reiterations of previous rulings by the court, but I still consider this opinion to be more of a win than a loss for Canada. So before I get into why the majority found the designated project scheme to be unconstitutional, I just want to quickly go over what are the constitutional issues at play. So the provincial and federal governments, of course, derive their powers to make laws from the Constitution, with Section 1 listing federal powers and Section 92 listing provincial powers. The environment isn't mentioned in either of these lists. Instead, the Supreme Court, including in this case, has repeatedly described the environment as a diffuse matter that touches on several heads of power that fall to both the provincial and the federal governments. Some of those powers are explicit, like fisheries and navigation and matters related to Indigenous peoples and their lands. Some of them are found through the peace, order, and good government power that Parliament has, which the Supreme Court has turned to find authority for things like marine dumping. At the provincial level, its main powers are natural resources and forests, electricity generation, and really everything local, like local matters, local works and undertakings, projects occurring on provincial crown lands. And as well as finding that the environment touches on several heads of power held by both the provincial and federal governments, the Supreme Court has also found that particular projects may have more than one aspect, with one aspect being provincial and the other being federal. So this is known as the double aspect doctrine, and it's well established in the case law and reiterated in this decision in the Impact Assessment Act reference. In this case, the majority turned to the example of a mine to point out how the double aspect doctrine applies. So if the activity of mining is regulated by the province, while impacts can be federal, for example, impacts on fisheries or navigation, and those are regulated by the federal government. So in this way, a mine has both a federal and a provincial aspect, and each of the provincial and federal governments can validly regulate the aspect that it has power over. So this principle is important when I go into why the majority found the act to be unconstitutional, which is essentially that the majority was concerned that the act isn't sufficiently focused on federal aspects, on federal matters. So while the act talks about federal effects, the majority found that it's actually aimed at regulating designated projects as a whole. The majority confirmed that the federal government can assess and regulate projects so long as the dominant characteristic of the law is aimed at the federal aspects, like the federal effects. And it said that under the Impact Assessment Act, that focus is insufficient. There are 4 reasons why. First, it found that the definition of federal effects is overly broad, as is the prohibition section. It also said that the agency's initial screening decision in the planning phase about whether a project requires an assessment doesn't sufficiently focus on federal effects. And the public interest decision it held also doesn't sufficiently focus on federal effects. So I'll explain each of these reasons in a little more detail. So first, the Act defines federal effects as including all changes to things like fisheries, navigation, migratory birds and species at risk, as well as effects arising in one province and occurring in another, what we call interprovincial effects, and all changes to the social, economic, and health conditions of Indigenous peoples. The majority said that definition overshoots actual jurisdiction over federal effects, particularly when it comes to interprovincial effects and effects respecting Indigenous peoples. Its main concern with interprovincial effects is, of course, greenhouse gas emissions. In the carbon tax reference case, the court set out a test for finding whether something like GHGs are a matter of national concern that would bring them under federal jurisdiction. And in this case, Canada did nothing in either its written arguments or in the hearing to show how greenhouse gases in the context of an impact assessment meet that test. So fundamentally, the court is concerned with something valid, which is that because greenhouse gases relate to virtually all aspects of our economy, it would upset the balance of federalism for the federal government to be able to claim sweeping authority over all greenhouse gases in any context, in any amount. I'm not going to go into the implications of that finding here, but as Alexis mentioned, we are doing a second webinar on November 14th that focuses more on the climate aspects of the decision that we welcome and invite you to attend. So the other issue that the majority had with the definition is that it captures all changes respecting Indigenous peoples, which it says goes beyond the scope of the federal power over Indigenous peoples, because according to the majority, that power is fundamentally aimed at Indigenous peoples' well-being, and including, as this definition does, potentially trivial impacts or even benefits in the definition, the majority says oversteps that focus on ensuring well-being. I think, it just remains to be seen what the practical implications of that finding is, whether there will be any material difference in the federal power. I'll also just note that the majority raised a question of the reach of the migratory bird power, which was a bit bizarre because it didn't come up really in the hearing or in factums. And the court didn't actually set out what the proper scope might be, just that it needs to be rooted in the convention around migratory birds that Britain entered into with the United States. So overall, some problems with the definition of federal effects, but probably not requiring major changes. The second main issue is a related issue, which is the prohibitions in the Act. So the Act prohibits proponents from doing anything that might cause federal effects. So this is tied to the definition of federal effects because that definition, as I mentioned, includes any changes, not just adverse impacts, which the majority says overshoots the mark. What the majority says should happen is that the prohibition needs to be focused just on preventing adverse effects, not any changes, whether they're good or bad, to areas of federal jurisdiction. So I disagree with the majority's reasoning here. The Constitution doesn't distinguish between good or bad, adverse, and benefit. But ultimately tightening up this language probably won't have much, if any, practical effect. So I see this as a fairly minor finding. Thirdly, also, I think fairly minor, is that the majority wants to see that the agency's screening decision in the planning phase better prioritizes potential for federal effects. So right now, in the planning phase, the agency has to decide whether an assessment is required by considering a number of factors, including possible adverse federal effects. The agency said that it was already making that decision by considering adverse federal effects. And really what the majority just wants Parliament to do is amend the Act to make possible federal effects a more prominent feature of that decision. So for example, Parliament could just make possible federal effects a prerequisite for an assessment. Again, I don't think this will practically change the way decisions are being made under the Act. And so it's not a major finding. But finally, and this is where the decision gets bad for Canada and for communities, in my opinion, the majority took issue with the public interest decision, which is, the biggest area of concern environmentally. Under the Act, the minister or governor and council has to decide whether the adverse federal effects of a designated project are in the public interest in light of 5 factors, as I mentioned before. But the majority found that even though the letter of the law focuses on adverse federal effects, the spirit of the law doesn't. For 2 main reasons. One, the majority said that some of the factors listed are focused on the entire project, like whether the project fosters sustainability or whether the project helps Canada meet its climate commitments, which the majority says indicates a focus on regulating the project as a whole and not just the federal aspects of projects. And secondly, and this is the most concerning part of the decision for me, the majority said that federal decision makers should only be able to consider the non-federal benefits of projects when deciding whether the adverse federal effects are warranted, and that authorities should not be able to consider the non-federal adverse effects. So in other words, it said that decision makers can justify federal effects by looking at benefits like jobs and the economy, but it can't consider whether the federal effects are not justified in light of additional non-federal impacts. So this finding is highly problematic, as it essentially suggests that federal ministers can't consider the full implications of the decisions that they make, and that they have to make those decisions in a partially blinded way. So just to put this into sort of a more practical term, let's go back to the example of the mine. Let's say the mine is proposed near a local community and it's going to turn a lake into a tailings pond. And let's also say that the construction and operation of that tailings pond could result in ambient air pollution that affects the local community members' health, and that the workers who are building and maintaining the tailings pond are going to be housed in the community, which would create pressures on housing and health services. So in other words, we're seeing lots of potentially significant adverse spin-off effects of this federal decision. In my opinion, and in the opinion of many of the interveners in this case, it's critical that decision makers are able to see all of these angles before allowing federal harms to occur. I think that this is the place where, when thinking about amendments, the federal government is going to have to do its most amount of thinking to make sure that it crafts a new decision function that preserves federal authorities' ability to make sound and informed decisions. But just because I don't want to end on a bleak note, I want to reiterate that we did get some really good language out of the majority. Its main complaint, as I mentioned, is that the Act isn't sufficiently focused on adverse federal effects, but it did confirm that federal assessment laws can apply to provincially regulated projects. It explicitly rejected Alberta's argument here and said that just because the activity aspect of a project that falls under provincial jurisdiction, like mining, that doesn't create an enclave of provincial exclusivity. In other words, the federal government can still regulate the federal aspects and can still say no to federal impacts. It also preserved federal ability to trigger assessments early on where there's just the potential for federal effects, and confirms that during assessments, authorities can consider all relevant factors. And I think that's important because even if there may be some limitation on what authorities can consider when making decisions, which I maintain is wrong and will need to be revisited at some point. Bringing in a broad scope of information during the assessments can still be really helpful because it helps ensure that assessments play that important public transparency and legitimacy role that impact assessment is fundamentally meant to do. And it can also make sure that we're making really informed decisions around impacts on Indigenous rights and authority. So, wrapping up, what now? Because the court's ruling is just an opinion, the Impact Assessment Act remains in force until the feds amend it, which they have said they will do as quickly as possible. In the meantime, the federal government has issued guidance that says that the agency is going to review all assessments that are underway to make sure that there's clear jurisdiction for each. So projects that are in the hopper stay in the hopper. They just need a review to make sure that there is that federal hook. And the agency is also going to make sure that during its Section 16 screening decisions that it will focus on potential for federal effects. The minister has said that he's not going to exercise his authority to designate new projects at the request of members of the public or Indigenous communities. Projects that are listed in the regulations will still be subject to the Act's requirements, although it's not clear whether officials intend to enforce those rules. But presumably, new projects will still need to go into federal assessment. And then finally, the guidance confirms that regional assessments will continue. So my last slide, just to close on possible amendments, I'm sure that the agency and the minister and their lawyers are busy assessing the opinion and thinking about amendments. At this stage, I can only speculate about what they might do. In my view, the amendments should be relatively straightforward and likely just related to those 4 areas that I outlined. So the definition of federal effects, the prohibitions, the screening decision, and the ultimate decision provisions. Usually we'd be looking at a kind of lengthy process involving memorandums to cabinet, drafting instructions, readings, and committee reviews in the House of Commons and the Senate. There may be ways to speed up the process from how long it usually takes. We could see an amended act around this time next year, possibly even before Parliament rises for the summer break, but there's always lots of factors that play into, parliamentary proceedings and how long things take. In the meantime, as I noted earlier, the Act does remain in force, and overall, in my opinion, this was not the rule that Alberta was hoping for. It was really just the court's attempt to ensure workable and balanced federation that requires some fairly minor tweaks to, bring the law into compliance with. And on that note, I will conclude. Thank you very much, and I look forward to your questions.
Thank you very much, Anna, for that helpful overview. So now we are going to turn it over to Stephen to share some thoughts on the implications for nature, and then we'll have a chance to get to questions and discussion in the Q&A. So just a reminder, the chat is open now. Apologies for the delay on that. You're welcome to add questions there or in the Q&A function at the bottom. So over to you, Stephen.
Thank you, Alexis. Good morning, good afternoon, everybody. I guess I'll be talking about what this means for nature. And I'll be repeating a little bit some of the points that Anna made from a perspective of what it means for Canada's ability to halt and reverse biodiversity loss and conserve nature in general. So that's where I'll be going with this. Next slide, please. So the presentation, I first wanted to just mention, like, why does federal impact assessment actually matter for nature? And secondly, talk about the impacts of the opinion from a constitutional, political, legislative policy perspective, and then give some thoughts on how impact assessment federally can be aligned with the Supreme Court of Canada's opinion. And then finally, a few thoughts on next step for nature groups. Next slide, please. So why does federal impact assessment actually matter? It is true that very few projects are actually stopped by virtue of a federal impact assessment resulting in a decision from a federal authority. I mean, there have been some of those. There's a number of pipelines, et cetera, that the government has said no to following an impact assessment. And those decisions have all been good for nature, as far as I'm concerned. In other cases, you get projects that, while they were approved, in the case of the Mackenzie Gas Project, approved by the National Energy Board, as it then was, but proponents actually learned something during the course of the impact assessment and abandoned the project. And in the case of the Mackenzie Gas Project, the oil companies involved saved literally billions of dollars by not investing in what surely would have been a white elephant, building the Mackenzie Gas Project from to bring small amounts of gas from the Mackenzie Delta to Alberta. So impact assessment matters. Projects that are approved are also approved by virtue of the science that's been done and the public engagement, and that often gets forgotten. The other benefit overall from federal impact assessment is that provinces are more inclined to actually do stuff in assessment. When the SIA in 1992 was passed, I think all provinces basically brought forward impact assessment laws. And as the federal regime has over the years been watered down, you see how some provinces, with the exceptions of British Columbia, Quebec, I think, their processes have deteriorated. So one really negative outcome that could come from the Supreme Court of Canada decision is that provinces can say, excellent, we've got the feds out of the way, now we can ignore this stuff ourselves. Next slide. So I want to just, and this is a bit of a review of what Anna just mentioned, but I think it's important to emphasize, given the media, which its provinces have been trumpeting this decision as a huge win for them, which it is not. So the constitutional thumbs up. The feds have broad authority to conduct impact assessments. The project list itself is constitutional. The feds can look at, in any assessment, they can look at a broad scope of factors, such as impacts on nature and on biodiversity, even though those may not be, strictly speaking, federal areas of jurisdiction. And most importantly, and I think this is a phrase that's worth remembering, there is no provincial enclave of exclusivity. Alberta wanted to say that the feds have got no right to say no to decisions where the primary regulatory authority falls to the provinces, such as for mines, coal mines, etc. The feds said that's not true. The federal government can regulate within its areas of jurisdiction. Next slide. Anna has mentioned some of the issues, and I won't go into those in any detail, but the key one really is the extent to which the federal public interest decision was deemed to be unconstitutional, and that does affect nature in a number of ways. The whole question of sustainability. I mean, I was one, and the Supreme Court majority disagree with me, that thought that sustainability should be a broad approach that the Fed should be taking to determining whether or not projects should go forward or not. Well, the court has said, well, sustainability is too broad. It's much too broad for federal areas of authority, so you can't go with that. You got to stick to your lane, and your lane is fish and fish habitat, navigation, etc. So the ability, the feds can't make decisions or set conditions in those decisions on, for example, on species that are subject to exclusive provincial authority. Anna's mentioned these odd statements with respect to the Migratory Birds Convention Act, but it raises questions as to whether or not recent changes, or they aren't that recent actually, I think they're the 1990s, but changes to the Migratory Birds Convention Act, because they veer off somewhat from the convention itself, whether or not that renders them suspect, at least with respect to the Section 7 prohibition. Next slide, please. So the fun stuff, political, the maybe more controversial stuff. So what's the political impact of the Supreme Court's decision? Frankly, I got to say that well, Mother Nature's on the run. And for those of us old enough to remember the Neil Young song from the 70s, the media messaging has been, this is a big provincial win and the feds have lost and there's all this confusion, etc. Now, Ministers Guilbeault and Wilkinson have downplayed the Supreme Court of Canada's opinion. They say that, listen, we've been doing this stuff all along since 2015. And to the extent that amendments are needed, they can be surgical, targeted, et cetera, and we can achieve alignment fairly easily. So that's been kind of that's what they've been saying. But the reality internally is that Minister Guilbeault has been very much politically damaged by this, even though he wasn't the minister that brought this bill forward in 2019. The Prime Minister did, and Minister McKenna at the time was the minister in charge. And Minister Wilkinson, when he was Environment Minister, he was in charge of implementing it for the first 4 years or so. So anyway, yeah, I mean, I personally feel for Stephen Guilbeault in this, especially coming on the heels of the government's decision to back away from carbon pricing. And internally, I mean, you can see this in Ottawa, that ministers opposed to impact assessment, which are frankly most of them, are taking political advantage. The agency interim advice, for example, it really, well, by taking away Minister Guilbeault's discretion to designate projects, I mean, you're tying his hands and you're making him look like he doesn't know how to do his job. And this Sean O'Regan committee the Cabinet Committee on Regulatory Efficiency, they're going to have responsibility for bringing forward amendments to the act, and so I expect that crowd to do their worst, frankly. So overall, I mean, the politics in Ottawa is that the next election seems to be governing almost everything that they do in terms of protecting seats in Atlantic Canada, or in the cabinet shuffle, it was all about trying to hold on to marginal seats. Biodiversity and climate are not the priorities. I think, to give them credit, climate and then biodiversity have been priorities over the past number of years, and they were on a good track. I don't think that's the case anymore. But we'll have to see, and it's in a way, it's up to the nature community and the environmental community to work harder with the public and change opinions. I think one other political impact, I think I've mentioned it already, is that provinces are going to say, listen, we've got the feds out of the kitchen, now we can do even less, because there's nobody there looking over our shoulder. Next slide, please. So in terms of the legislative and policy impact so far, we've mentioned the interim advice from the agency means that there's all sorts of projects that surely demand important impact assessments that will not be assessed. There's a list there, I won't run through them, but in my view, they all have important they all fall within areas of federal authority, and there's a good argument that they should be designated, at least some of them. Now they won't be, and the government says that they're not going to designate any projects not on the project list until legislation is passed. A second policy impact is this project list 5-year review, which the agency has just started up. I think it's likely to result in fewer designations than we even currently have, unless the nature community and the environmental community really does some work. I've mentioned this regulatory efficiency committee headed by Minister O'Regan. Don't see much good coming out of that, but again, partly it's up to us a nature community to do our job in terms of advocacy and lobbying. Next slide, please. So in terms of the legislative options, Anna has indicated, and the government has indicated, that it seems like they favor making some targeted amendments to the act in order to bring it into alignment with the Supreme Court of Canada opinion, and that may be the way they go. There's some other suggestions that have been made. For example, bring back the old statutory regulatory triggers from SIA 1992, because we know that that's a constitutional approach according to the Old Man decision. Another approach would be to rewrite the act altogether and basically just bring back SIA 1992. I know this is the approach that the Green Party has advocated for some time. And the other approach would be just do a comprehensive rethink. In terms of timing, what they could do, and this might, if this O'Regan committee comes forward quickly with some amendments, they could actually go in the 2024 budget bill into an omnibus bill, following the model of the Harper government in 2012. So that would be a sneaky way of doing it, because it would ensure that there wouldn't be that much discussion in Parliament and they could just ram it through. A second option would be to introduce a standalone bill and rush it through Parliament, before the election, and the election may not happen until October 2025. But that conceivably would be enough time if they made it a priority. The other option, and this is the one I kind of favor, is that I don't see any big need to rush through amendments right now. I would be more inclined to have the government take the time, figure this out, so that we can get legislation that actually works. Right. So next slide. I think I'm pretty much done here. So just focusing on nature groups, and I appreciate that that lots of folks on this call are maybe work for government, so hopefully I'm not giving away any strategies, etc. But I really think that the nature groups and environment groups, we've got to actively campaign for a federal assessment process that achieves nature and climate goals. That's got to be the objective. And we've got to lobby hard so that the government doesn't back away from that, and then we get legislation that actually pursues those goals more effectively. The public has got to be engaged. I mean, I frankly see this O'Regan committee as being a secretive process, and they're just going to dump these amendments into the House, and we're going to have 2 weeks to complain about them before they're enacted. And I think the other thing that I think has to happen, and something that the government I think has done very poorly since the act was passed in 2019, is to communicate effectively what environmental assessment does and why the federal government has an important role to play. There's been so much misinformation, and you see this continuing with the commentary on the Supreme Court of Canada decision. Lots of folks like to, I'll just say there's been lots of misinformation out there, and I think we, as nature groups, we've got to support accurate information that shows why impact assessment is important and how it can be made to actually help Canada reduce its greenhouse gas emissions and halt and reverse biodiversity loss. So I will stop there. The next slide had just, I work with Nature Canada a little bit, and I also have a little company, Ecovision, and there's some information there that relates to this stuff as well. Anyway, thank you so much for your attention, and I guess we can get on to questions.
Thank you, Stephen. All right, so we do have about 20 minutes for questions right now. And we have some questions that came in during registration, as well as questions coming in through the Q&A right now. So why don't we start with one of the questions that came in earlier. And I should also just reiterate that, yes, the presentations have been recorded. So if you're looking for anything after this, we'll be sending a recording around to anyone who registered, and we'll likely put it up on our YouTube channel as well. All right, so one of the questions that came in earlier was how will assessments of specific projects like the construction of Highway 413 or the development of mining in the Ring of Fire in Ontario be affected? And similarly, what impact does the decision have for future BC resource extraction or processing projects?
Do you want to take that one, Stephen, or do you want me to?
You go ahead.
All right. Yeah, so like I mentioned in my presentation, the projects that have already been triggered, that are already in the assessment, that are going through some form of assessment or in some phase, they stay in. So the agency is going to review them to make sure that they do actually have the potential for adverse effects. But so in terms of projects that are in the hopper, I don't think we're going to see much of a change because of the fact that the project list regulations so intentionally focus on projects with the most potential for areas of federal jurisdiction. And the agency has said that it, has always intended to screen assessments for the potential for federal effects. So I'm fairly confident that the ones that are already going through assessments are going to remain in there because they do have the potential for federal effects. The Ford government has challenged the Highway 413 designation in the federal court, but that's a slightly different matter. So, it'll continue to need to go through the assessment until the federal court has decided on, whether or not that designation was appropriate.
Anna. So another question that came in during registration was, what advice is suggested to the federal government and policy lawmakers to make the amended Federal Bill C-69 or Impact Assessment Act more stringent and less likely to be challenged in the courts?
Well, I think a couple of things. One is that we're going to have to change the decision-making process, and I think that's the key thing. And Anna has pointed that out. How that actually gets done is it's problematic. So I don't have easy answers to that at all. But I think that's the area that really needs the most work. But I think one way to make it stronger would be, going back to C in 1992 and the use of the decision-making triggers that the federal government has with respect to statutes and regulations, with respect to funding, with respect to lands, and with respect to funding. We probably wouldn't go to all of those triggers, but at least with respect to regulatory triggers, we know that the federal government has constitutional authority to regulate in those areas. So focusing in on those, and I'm not sure how you would rewrite the project list to require that all projects requiring requiring a Fisheries Act authorization are subject to assessment. But I think language like that could be developed. So because right now a lot of these projects are just not being assessed. Yes, an authorization under the Fisheries Act is maybe required in some situations, but all the other stuff that should be assessed are not being assessed. So those are a few thoughts. Anna's probably got others.
That's pretty good. Maybe we'll get to some other ways when we're answering the other questions.
All right. One other question, just throwing it over to the Q&A here today. Can you dig into the court's decision on federal jurisdiction over sustainability a little bit more? Shouldn't it be the responsibility of the feds to ensure Canada is meeting its sustainability and climate commitments?
Yeah, maybe I'll jump in on that one. I mean, I think, sustainability is really a state of being for multiple aspects of the environment, right? And so it's definitely federal responsibility to ensure the sustainability of federal matters like fisheries, but sustainability, like, first of all, I'd say that the feds don't have sole responsibility for ensuring sustainability, and the provinces have to be pulling their weight in ensuring the sustainability of, provincial matters and the well-being of Canadians. In terms of climate commitments, I mean, under the Constitution, the fact that Canada has entered into an international treaty doesn't automatically give it jurisdiction over that matter. And so, yes, I would say that the federal government does have responsibility for, ensuring that it meets its commitments, but how it does so is a different question, right? In doing so, it has to stay within constitutional bounds. And so that's the trick that I think is before the federal government, both under the Impact Assessment Act and then under other federal legislation, whether it plays a backstop role like it has with the carbon tax, whether it does so through the criminal law power like it's doing through the clean electricity regulations and its proposed oil and gas emissions cap. How it does so under the Impact Assessment Act, might be a combination of carrots to the provinces and considering factors, figuring out, as Stephen has pointed out and as I talked about, how to factor those considerations into decision making. So the short answer is yes, but not just the feds. And that doesn't necessarily give them sweeping jurisdiction to do whatever they want in the name of advancing sustainability and climate action.
Thanks, Anna. The next question from the Q&A is, do you think that nature's place in impact assessment will be predicated on the boundaries articulated in the federal government's proposed biodiversity legislation in order to place biodiversity safely in federal jurisdiction?
No. I think that assuming we get some legislation on biodiversity accountability, and the suggestion is that there should be legislation that would mimic in some way the Canada Net Zero Emissions Accountability Act for greenhouse gas emissions. That legislation would have to be very carefully circumscribed to ensure that it doesn't impose any obligations on provinces or exceed federal authority. And there has been no challenge to the SNEEZY Act, as we call it, the Net Zero Emissions Accountability Act. So we're thinking that if the Biodiversity Act was similar, we shouldn't face any constitutional obligations there. But what a Biodiversity Act would do would set standards for the biodiversity action plan that Canada is required to submit, and it would set standards for that, and it would put pressure on provincial governments to actually do their job, and it is mainly their job to conserve nature and halt and reverse biodiversity loss in the provinces. And if they don't do that, if certain provinces are dragging their feet, then it'll be up to the nature community to call them out. But we'll be able to call them out because there will be a reporting framework. So I don't know, that may not be coming at the answer directly, but that's the answer I wanted to give.
All right, thanks, Stephen. Another question here from the Q&A is about the project list. Are nuclear plants or refurbishments not also on the project list? Are they on it or not?
Some nukes in some situations are on the list. If there is a new nuclear reactor that's on in a licensed facility, it's not required to be assessed. And most controversially, the small modular reactors were deliberately left off the list, even though it's an unproven technology. The waste is different from the waste that comes from the conventional reactors. In my humble opinion, that the small modular reactors, they should be listed, but they aren't right now, and that's a change that the government could make, and the Supreme Court's decision has no bearing on whether or not they are added, because there is no question that atomic energy, nuclear energy, is a matter for exclusive federal legislative authority.
Can I just jump in here, Alexis, because I see a few questions that are related to the project list approach and projects that are on the list. And I think it's worth reiterating that the court took no issue with the project list approach. The project list approach is fine. It's constitutional, right? The court explicitly said it has no complaints about the project list approach from a constitutional standpoint. The projects that are on the list are fine. And it said that to designate a project, the feds only need to see that there's the potential for federal effects. So it's it actually said the words low jurisdictional threshold. There isn't really an issue around triggering. The court didn't find an issue around triggering. What it found ultimately was around the prohibition and the final decision. And so, I think that's really important to keep in mind, because the agency does have this legislated 5-year project list review. And in my view, this opinion gives the federal government a huge amount of leeway to significantly add projects to the list based only on the potential for those projects to have an impact on areas of federal jurisdiction. The trick is that once projects are in the planning phase, that agency screening decision just has to make sure that they verify that the particular project that has come in does have the potential for federal effects. So like nukes are fine, impacts on that's all fine. The project list approach is fine, and just the potential for federal effects is fine. I think the sticky issue with the decision is around the ultimate decision that the minister has to make and how that can be made in a fully informed and sound manner.
Thanks, Anna. There's another related question here about, so I guess this pause on adding new projects to the list means the proposed deep geological repository for Canada's nuclear waste won't go onto the list?
I think I just answered that.
Got it.
It could be on the list.
Good suggestion. We'll have to put that one forward.
Thanks. So another question about triggers. Surely the federal responsibility for Indigenous rights would trigger some of the types of projects Stephen mentioned that might not trigger an impact assessment.
This is complicated, Anna, so you better speak to it.
I think this one, and I am not an Aboriginal rights lawyer, but I think that it depends on whether or not impacts on rights are a result of any kind of a federal decision, right? Because again, the provinces also have authority for upholding and respecting Indigenous rights and for consultation and accommodation. So I would just come back to the point that I made that, we can see a much more robust project list approach than the one that we have, because this decision has carved out a fair amount of federal jurisdiction, and that could be related to impacts on any areas of federal jurisdiction. Impacts on Indigenous rights may need to be related to another federal head of power, like if by authorizing impacts on fisheries, that would infringe Aboriginal rights. But again, I'm not an Aboriginal lawyer, so I say that with that caveat.
But Anna, didn't the Supreme Court raise some doubts about the scope of the factors relating to there's quite an extensive list of factors relating to Indigenous lands and rights, and they I think they indicated that it was too broad, or it was some language like that made me think that whether through amendments or through some policy process, that would have to be narrowed. Is that not right?
Yeah, they did say that, although I don't think that actually it is that what the feds have to do is that much narrower than what they've already asserted jurisdiction over. So right now the act says this isn't in the language of impacts on Indigenous rights. This is the language around just changes to the cultural, economic, and health conditions of Indigenous people. So it's not like a constitutional rights issue. It's just impacts on Indigenous peoples themselves. And the court just found that, as I read it, the majority said that that jurisdiction can't include non-trivial and non-adverse effects. So basically, I still think it carves out federal jurisdiction over any non-trivial impacts on Indigenous peoples.
Another question here that's interesting. Is there any opportunity for the feds to incorporate any sort of requirements for provinces to ensure that there are EIAs being done to meet some level of minimum requirement?
I think the answer is no.
I agree. Yeah, I think that the backstop function that the court upheld in the Carbon Pricing Act reference case differs in this case because, first of all, impact assessment pertains to so many things and many things that are clearly within federal provincial authority. So, the court has fairly clearly said that when it comes to aspects that fall within provincial regulatory authority, the feds have to stay in their lane. So they can't start getting into the job of regulating or coming up with backstops or minimum standards for the provinces in the areas that they clearly have regulatory authority over. It would probably also cause the provinces to further light their hair on fire and run around the room screaming. So from a political perspective, I'm not sure it would be entirely wise, although perhaps desirable in some jurisdiction.
Thanks. So I think we have time for one more question, and maybe let's talk a little bit more about that political side and public advocacy. Stephen mentioned that the public should be engaged. What are the examples of public advocacy and mobilization messaging that can be effective to garner support for the Impact Assessment Act?
Well, I personally think that, look, start off by saying impact assessment is not normally a very sexy topic. And, over the years, I mean, and Anna will fulminate on this subject as well. Over the years, we've had a lot of trouble getting journalists to take interest in impact assessment and issues such as like the failure of the agency to provide any reasons as to why certain projects were put on the project list, why certain thresholds. They've basically provided zero information despite access to information requests and petitions to the parliamentary commission, etc. So we really have to really focus on that communication going forward.
Thanks so much, Stephen. I think that is pretty much all the time we have for questions today. Apologize we didn't get through all of them, but we can maybe follow up with a few of them later. And again, we will have our second webinar on November 14th at 10 a.m. Pacific, 1 p.m. Eastern, about assessing the impact, Ottawa, Alberta, and next steps for climate policy. I've pasted that in the chat, and it's also available on our website. So thanks everyone for this really great discussion on Impact Assessment Act. As Stephen said, it's not usually the sexiest topic, but I think this is the one of the hottest times we've had talking about this issue. So thanks again for your insights and for all the questions and participation, and check out our website and hope to see you soon.
Thanks, Alan. Thanks, Alexis, for wonderful stick handling.
Take care, everyone.
Bye.
Bye, everyone.